hear a case deemed frivolous. If a case is deemed frivolous or without merit, the court shall issue an opinion justifying such action, which is to include rationale for making that action.
Point of information.
Go ahead. Am I out of context?
Look at 6.4.4.
Okay. Either way, 6.7.5 exists.
And that's correct. 6.4.4.4 says something different.
6.4.4.
Or it might be 3.
4.
Okay.
The Supreme Court shall hear and decide any properly brought cases concerning the SGA Constitution or bylaws as set forth under 6.7 of the SGA Constitution when such cases have merit. Also, it's 6.4.3, I'm sorry, Paul. Hear any challenges under SGA election rules and assess any penalties where appropriate. So both of those blurbs exist in the Constitution bylaws.
So just going back to the latter, where we're talking about hear any, it's my understanding, and feel free to argue with me, Paul, if you'd like, that any doesn't necessarily mean all. So if the Constitution says any, then my interpretation of that is the court, under their discretion, has the option to hear. Any doesn't necessarily mean, or well, not necessarily, it doesn't mean all. And so I guess that's my first thing. Now the other issue of certification, I was at that meeting, and I think what happened was we passed a resolution to say such and such, and then at that exact moment Alex came in and I think you said we've already decided, right? Is that pretty much a fair estimate of what happened at the last meeting we had here? So because you all had already made the decision before we passed the resolution.
We actually just heard the case that was filed properly through the court, and that's all.
Okay. So I guess that's my first thing, and I guess that's my only real comment. If I can yield now?
You have a minute to yield.
Okay, to Brian Day.
Yeah, I'll speak to Daniel's point, and I will say what someone brought up, I guess, Allison, about the context. This is an impeachment proceeding, and back to Daniel's point, we're talking about constitutional interpretation, and you're talking. Yeah, I understand the electorate's vote matters. Don't assume that we took that lightly when we were in the room making these decisions. They were difficult decisions. That said, as Alex said, it is a matter of interpretation, and that's what the court does as the third branch of the SGA. As Daniel Cameron just stated, the Supreme Court shall hear any cases, not all. That's permissive language. That, coupled with a more definite part of the Constitution that Megan Reeves just read, states that we determine as the court what cases have merit and not. Thus, we do not have to hear cases that have merit. I understand transparency is important to student government, but so is the power of the third branch of the Student Government Association. And I'm not telling anyone, because I'm the law student representative, how to read.
I'm sorry. Linda.
I think it's a good point that the court has the discretion to hear or not hear cases as they choose based on merit. So on that point, the fact that they chose not to hear a case, supposedly because it was not a meritorious case that was about voters being disenfranchised, makes me question the judgment of the court, which is, I think, a good point to raise when we're considering whether or not we like the decisions or not even like the decisions. I don't necessarily want to like or not like. That's not even my issue. I don't have a personal issue here at all. It's about whether or not I think that the court is using good judgment, whether or not I think that they are really fit to be in the position that they're in. If they don't consider disenfranchisement an issue of merit, then to me, that's bad judgment.
Point of information. That's an interrupt, so I'm allowed to do it.
Gotcha.
What cases did the court hear related to the election?
Point of information, I'm directing that to you, Chief Justice Fromeyer.
Amber Carrier et al. Versus Supreme Court.
Point of order. It was not heard via Title VII.
Okay, his question was answered. Your point of order
Is that
was
a
answered.
point of information? Is that the only case that was heard regarding the election?
That's what I just asked.
We heard 4 cases in addition to that in one night during the election season.
My question was, what was the point of the cases? Like what? Obviously, there's one case involving voter disenfranchisement. What were the other cases that were being heard about
Alex,
the subject
can you
matter?
answer that?
I don't think my laptop's hard drive has all that right now.
Okay.
Can I point of information, Alex, could you give like a state of law, like what the finding was of those cases?
What's that?
Could you give like a state of law? Is that the right word? I'm trying to think.
The disposition of the case?
Yeah, just kind of, like
A summary of your
a
findings
short, like,
in the case.
what the issue was, what the finding was.
Bring it back. He has the floor to answer his question. Nobody else does. Go ahead, Alex.
Can you re-ask the question? I have no idea.
Could you tell me like what the issue was of those 4 cases?
That's what I just said. I don't have it right in front of me right now. There are opinions on all of them.
When did you hear the 4 cases?
Wednesday of the election, of the original election period.
Okay, we're back in.
Point of information, may I read from the SGA cases and state what roughly each case was about?
You may read it, yes. And then Mike Warren gets his floor.
All right. Advisory opinion 10-0, a Facebook group that was created before the election. Advisory 10.0 again deals with court candidate in a window as a student activity center, multi-purpose room, exercise advisory power, issues of the court in the first person. I'm not sure whether this actually says what it's about in the title. Display candidate and slate information in the window. That's what it says in the beginning. And the other one is candidates, in addition to other student groups, have contacted concerning illegal placement of flyers, chalking, and general discretion on private property. Those are roughly what they were.
Thank you. Mike Warren, you have the floor.
I yield the floor to Associate Justice Bevan.
Thank you. Brian Bennett, you have the floor.
Yeah, I'll speak to that point first. The Wednesday during elections was not the time that this case was filed, Amber Carrier et al. Versus the court. And so that's not necessarily the right place to be looking at the proper. We deemed this to not have merit, therefore we didn't have an official opinion. There was an advisory opinion, if I'm not mistaken, from Alex Fromeyer or Ben Shepard, one of the two. But it would not be found in the same place that those 4 other cases would have been found, because that was on a separate hearing night. And might also add 704.1, providing the definition of hearing. If the court deems that there's no merit to have a hearing, the definition of hearing does not matter. The definition of hearing only kicks in or triggers after the court determines whether there's merit to hear a case.
Point of information, what about Title VII though, that says what a hearing is?
That's what I'm saying. In the closed session,
No, that's not Title VII of the bylaws. You're reading from the Constitution. I'm talking about Title VII of the bylaws.
I'm reading from the bylaws. In the closed session prior to commencement of the hearing, it talks about, it defines what a hearing is. Okay. And if the court determines that there's not reason for a hearing based on not having merit, which is what we decided in this case, then a hearing in Title VII of the bylaws is inapplicable.
Point of information, where in Title VII does it say that if the court decides there's no merit, it's not a hearing?
Can I jump in really quick with a point of information? That is to be used for a process question or a question about what's in the motion. So we're overusing that so we can speak more.
Yeah. So.
Thank you, Jerome.
I'll
59 seconds, Brian Bennett. Keep going.
Yeah, I'll just conclude that point in saying my interpretation as an Associate Justice of the Supreme Court, the Student Government Association, is that the language of hearing only is triggered should the court find merit to actually have a hearing. In this case, we did not. Therefore, we acted within our constitutional authority. Additionally, separation of powers. It's the Senate cannot tell us what cases to hear. If we acted within our jurisdiction within our proper authority, as I've already demonstrated through the express language of the Constitution and the bylaws, then the Senate has no authority to tell us how to act after we already acted within our proper authority. I really do appreciate your all's comments, your feedback. I do respect the students' ability to vote. In this case, that's not the issue. We're talking about our constitutional authority. And I'm sorry, what's your name? Linda, and I respect your opinion as well, but questioning our judgment is not your job, to be quite honest. Our job is to make decisions in our best estimation. I respect your opinion. However, in this case...
Okay. Curtis, did you have your hand up forever and a day ago?
Yes.
It's you, honey.
Give my time to...
It's your time to go. Brian Bennett, you have 2 minutes.
I may actually conclude this time for good, unless there's additional questions. people want to yield more time. But that said, that's the constitutional aspect of this. I'll get back to what I said whenever I first stepped up here. We set out to do a job just as you all set out to do a job. And I don't want to make this a personal thing, it's not, but we worked hard throughout the election cycle to make sure we came to the proper decisions. And again, with the context of this being an impeachment hearing, I will step outside of the role of SGA. I am kind of personally offended that you can't, or not that you can, I'm not talking to you specifically, Paul, but that it can't be trusted that we would make a decision and that, I mean, had we not got the chance to speak tonight, I didn't find out about the hearing or the meeting tonight until last night. Had I not got the chance to speak about this, you all would have just looked at a letter and said, oh, well, I guess the constitutional interpretation is right of one, or should I say two people, and therefore you're not even taking our consideration or our decisions and our timeless conversations into account. And so just trust that we made an informed decision, and based off the constitutional authority, we had that decision to make, and it was ours. So I will yield the rest of my time unless there's more questions to come.
Okay. First of all, you have your hand up back there. I'm sorry. Are you a senator or proxy?
Yes.
What's your name?
Kim Fleming.
Kim. Okay. It goes Cassidy and then Jeremy and then you, Kim. Thank you. Cassidy.
I think Allison made a really good point when she spoke. And I think another thing that some of us keep getting back to in all these discussions is that we need to kind of focus on the problem, and maybe the problem is not with the 7 people that are our court, but maybe the problem is with our Constitution. And instead of making resolutions to remove those people where other people can just step in and we have the same Constitution, we make constitutions to change words of any to all or something like that that we feel passionate about. Because I think as a Senate, if we felt passionate about something and we went into the works of something and we spent hours listening, and just like the court said they have, and someone didn't like it, or we felt that that was unjust, that they tried to impeach us, I think nothing's going to get done if you just don't like something and you start to impeach people. Or I know that's kind of personal or things like that, but I think we need to look at what is the problem. The problem might not be those 7 people. The problem might be our Constitution, and maybe we should look at that and start rewording that and start focusing on that so future elections and future problems do not exist.
Thank you, Cassidy. Jeremy?
Thank you. First, I just want to say real quick, as an outsider, I've kind of gotten to see more of the inner workings. This is only my 2nd meeting that I proxied to. And I can honestly say that I was a very concerned student throughout the whole elections process, and actually went to the court hearings. All 4 of them lasted a very long time, very late Wednesday. But I feel that the court acted in their jurisdiction, and I do not think they need to be impeached. They have done a wonderful job. I respect each and every one of them very much. I'd like to yield the rest of my time and forward to next Morley.
Next, Morley, you have approximately a minute and a half. Go ahead.
Does anyone here know the last time, and I know we're not actual American government, but does anyone know the last time that a Supreme Court member was impeached? It was 1806, and that person got impeached because they supported a Federalist candidate from the bench. Now, nothing of the sort has happened here, and I would argue that this kind of impeachment trial is completely superfluous because we've had it read to us that it's completely within their jurisdiction to do what they did. Now, between 1806 and even today, people in our Senate, people in our national executive branch have questioned the motives of our Supreme Court. Hell, they've questioned the judgment of our Supreme Court, just as we're doing today. But those people haven't been impeached since 1806. And that person was impeached because they blatantly supported one platform over another when the court is established to be an impartial body. Now, if they want to exercise their judgment, damn it, they have the constitutional right to do that. And if they want to use the part of the Constitution that says they have the right to say that a case has no merit, damn it, they have the right to do it.
Point of order.
And if we want, you didn't say anything after that, so I'm keep on. If we want to impeach 7 people for exercising their constitutional right, what are we doing here, guys? Do you think the students want to impeach someone for exercising the rights that we have given to them, that we have dedicated ourselves to support when you were sworn into this position? I don't think anybody on this campus wants that.